Paul, yes. Just looking at these agents, yeah. If the principal allows an agent to appear as if he or she has more authority, yes. Than the agent really has, the principal is bound by what the agent does. If the agent acts without authority, the principal is under no obligation unless the principal takes advantage of the act or approves it in some other way. Now, who's the principal in the employment of this state and every state? Coach, the state is. Now, just so you know, you say that as each and every state, right, the principal can take advantage of the agents known as court commissioner and judges, yes, to issue court orders where there was no express authority of law. Now, I'm sure about the meaning of the word express. Yes. Now, you issued a temporary protection order in 2011, right? But you issued a permanent protection order on August 12th of 2011. Who is it that issues these protection orders? Yes. It's the principal. Hang on just a second. Oh. Oh, it's the Court of Washington. Oh. It's not the Clallam County Court, the Court of Washington for Clallam County. It looks like the principal in every court order is the actual state. Yes. Now, the agents of the state are Clallam County. Yes. And the employees of Clallam County acting. Yes. Isn't that right? On behalf of the state of Washington. Now, does the Court of Washington state have the express authority, yes, to issue any court order without any actual notice of court hearings? Your mental health evaluation, Brent? Yes. Let's ask the principal known as the Court of Washington. Oh. The Washington courts. Yes. See, I've informed the state of Washington and every member of the state legislature, yes, that you took the express authority of the state of Washington, yes. You issued a court order in 2011 where I wasn't a resident, yes, of the state of Washington. Oh, you reissued a court order on May 31st of 2012, yes, motion hearing Brent Basden? No. As an employee, yes, of the county, yeah. That is the agent of the principal known as the state of Washington. Could you actually reissue a protection order while I was on trial for violating the fraudulent protection order? Yes. That the state of Washington issued as a principal, giving you, Clallam County, the express authority. Ouch. But there are certain RCW requirements of law. Now, the state of Washington's getting sued, ouch, for allowing for, as a principal, yes, is under no obligation unless the principal, known as the state of Washington, took advantage of the act and approved Clallam County's issuance of a court order. Now, known as the state of Washington court, the principal state of Washington, yes, is taking advantage of the unlawful act of issuing a court order where there was no enforcement of the RCWs. Yes. There was no enforcement of the federal laws. Oh. There was no jurisdiction over the parties, the minors, and the subject matter. Yes. See, it's the Court of Washington for FOR, Clallam County. Yes. It's not the Clallam County Superior Court. It's the Court of Washington for the Clallam County Superior Court. Now, I'm going to sue this state for $200 billion. Do you fucking understand? And then I'm going to sue every state of the United States because each one of them is known as the court of the individual states. The full faith and credit of the United States Treasury. Now, I didn't get a phone call from my sons because you, as a judge, yes, had decided that you were the principal instead of the agent for the state of Washington's courts. And you have the authority to issue a court order as a principal or as an agent. Now, let's look at it. Did the. Oh. Now, this is a Superior Court of Washington. Yes. Mm. Yes. Clallam County Superior Court. Oh. Exactly how do you have the express authority of the state of Washington as a Superior Court of Washington when a county issues a weapon surrender form? Yes, without the name of the petitioner, without the name of the respondent. Fraudulent statements that the restrained person, known as Paul Budnick, did not have actual notice and did not have an opportunity to be heard. Now, we looked at this yesterday. Yes, we did. It's not just actual notice as in, well, we tried to serve him, but we didn't. It's reasonable. Yes. Mm. It's accurate as in you sent it to the right address. And it's timely as in at least 5 judicial days prior to a court hearing. And the restrained person had the actual opportunity to speak to the court commissioner or the court judge. Now, when we use the victim's, the victim's definition, what the state of Washington did is they kind of abbreviated actual notice and an opportunity to be heard. But we learned, yes, we did, that the Superior Court of Washington State did not guarantee me accurate, reasonable, and timely notice of court hearings, and I was not given the actual ability to speak to a judge or judge. Now, thinking about the actual definition of due process used in yesterday's experience, for the Court of Washington State to allow for the express authority of its agents, yes, to issue court orders where there is the fraudulent statement that I, as the person named as the restrained person, but not named as a respondent, yes, I'm not only going to sue this state, I'm suing every state of the United States. Now, I asked you to remove your court order. Is there some problem with me having custody of my sons? Did you not realize that this is the Court of Washington State? This is the Court of Washington, order for protection, coach, for, Clallam County Court. See, the Superior should go from for Superior Court of Clallam County. You can't actually put Superior above the Court of Washington State. Now let's look at your authority. I've asked you to remove a fraudulent court order. As employees of the county, you said, no, we're not going to do that. And we're going to use the authority of the state of Washington without any express authority of the state of Washington and without the implied authority of the state of Washington, because the state does clearly and directly express to those in the sheriff's department. Now, I don't want to wait for you to make any more decisions. The Clallam County Court does not belong to Clallam County. It's the Court of Washington State that owns Clallam County.